Hello everyone, this is day 12 of Polity Daily Drill. Let's begin. First question. If the Prime Minister belongs to Rajya Sabha, which of the following is or are likely to take place? He will be allowed to vote if a no confidence motion is moved against the government. He will enjoy a longer term than the MPs of Lok Sabha. He will not be able to speak in the Lok Sabha during discussion on budget. Now we know very well that the Prime Minister can belong to Rajya Sabha. We have had various examples. Indira Gandhi initially, Indra Kumar Gujral in the 1990s, also H.D. Devegowda became the Prime Minister belonging to Rajya Sabha, and later on for a very long period, 10 years, that is 2 terms, Dr. Manmohan Singh. Now, coming to the question, can the Prime Minister vote for a no confidence motion if he belongs to Rajya Sabha? This basically stems from our knowledge of Article 88 of the Indian Constitution, which says that every minister and also Attorney General, they can take part in the proceedings of either house. When I say take part, meaning they can sit in either house, they can also speak in either house, and not just this, they can also become members of any committee of any house or a joint committee. That is okay. Meaning, if you are an MP in the Rajya Sabha, you can go and sit in the Lok Sabha, speak in the Lok Sabha if you are a minister. And vice versa is also true. However, voting right comes from membership. So you can only vote in that house of which you are a member. This means that if the PM belongs to Rajya Sabha, he cannot vote in a no confidence motion situation. Why? Because NCM can be brought only in the Lok Sabha. Hence, one is incorrect. Second one, he will enjoy a longer term than the MPs of Lok Sabha. That is true because since he's an MP in the Rajya Sabha, his term is going to be 6 years. The tenure of MPs of Lok Sabha is 5 years. 2 is correct. Coming to number 3, he will not be able to speak in the Lok Sabha during the discussion on budget. This is again incorrect. As I just said, Article 88 allows you to speak. And we do see the finance minister, the current finance minister, belongs to the Rajya Sabha, and yet she every year presents the budget in the Lok Sabha. That is where the budget is presented. So 3 is wrong. How many statements are correct? Only one. A is the right answer. Moving on to the second question. Consider the following statements. A censure motion can be moved against an individual minister or the entire council of ministers. Now, this is true. A censure motion can be moved against an individual or the entire government as well. Number 2, unlike a no confidence motion, a censure motion does not need to specify the grounds on which it is moved. Now, this is incorrect. In fact, it's the exact opposite. Why? Because when it comes to no confidence motion, no ground is needed to be mentioned for a no confidence motion. However, for a censure motion, you must mention the reasons, the ground, the reason needs to be mentioned. So this is important. Hence, this statement is incorrect. Number 3, the passage of a censure motion requires the government to resign. Now again, when it comes to a censure motion, the word censure is very clear. It simply means what? It simply means to reprimand. Reprimand or rebuke or formally scold. It in no way means that the minister must resign, right? It in no way has any impact on the government. There is absolutely no need for anybody to resign. So 3 is incorrect. And the fourth one, a censure motion can be moved only in the Lok Sabha. This is correct, absolutely correct. There are certain motions that can be raised only in the Lok Sabha, like a no confidence motion, a trust vote, adjournment motion, and a censure motion. So in this situation, A, 1 and 4 only being the right answer. Moving on to the third question. A judiciary that interprets laws in a manner that primarily benefits the government and its policies, thereby protecting their interests, breaches the principle of. So, whenever the judiciary tries to interpret laws in such a fashion that it tries to protect the policies, the interest of government, tries to uphold the policies and ideology of the government, irrespective of the impact it might have on the people, that judiciary is called a committed judiciary, committed towards upholding government's policies. So it's a negative term, it is not a positive term. Hence, the definition here is of a committed judiciary. And when this happens, what principle is breached? The principle of assertive judiciary is breached. What is assertive judiciary? A judiciary which upholds the rights of people. If any government policy goes against the rights of people, the judiciary might intervene and strike down the policy. Assertive judiciary. So when this happens, the breach is of the assertive judiciary. Right? So A is the answer. Otherwise, what is an integrated judiciary? Integrated judiciary means the decisions of the lower courts can be challenged in the superior or the higher courts. This is what is meant by an integrated judiciary which we have in our country. And competitive federalism is something else entirely. It simply means creating an environment of healthy, constructive competition amongst various provinces or states as we know them. So A is the right answer. Moving on to question number 4. Which of the following statements accurately reflect the characteristics and functioning of subordinate courts in India? Number 1. The establishment and organization of subordinate courts are primarily governed by the provisions under Article 233 of the Indian Constitution. Now, this is absolutely correct. Article 233 talks about the appointment, the qualifications for subordinate courts. Number 2. Subordinate courts have the jurisdiction to try both civil and criminal cases as per the laws governing their functioning. Now, this is also correct. The lower courts do have the authority to try both civil cases as well as criminal cases. Number 3. The Chief Justice of the High Court concerned has the sole authority to appoint judges to the subordinate courts. Now, this is wrong. Why is this wrong? Because the appointment of the judges at the lower level is done by the governor and not the Chief Justice of the High Court. Even though the Chief Justice has complete say, he has complete control over the appointment procedures, but officially the appointment is done by the governor and not the Chief Justice. And number 4, the control over subordinate courts, including the appointment of judges, lies with the High Court of the respective state. This is actually correct. They actually run the show there and they will make recommendations to the governor, who will then make appointments based on the recommendation of the High Court. So in this case, 1, 2 and 4 are the right statements, D being the correct answer. And the last question for today, question number 5. Consider the following statements regarding Article 20 of the Indian Constitution. It guarantees that no person shall be subjected to a penalty greater than what could have been inflicted under the law in force at the time of the commission of the offence. And number 2, it, however, allows retrospective application of civil laws to enhance penalties for offences already committed. Now, Article 20, we all know, has 3 different parts, one of which is mentioned here, that is no ex post facto law, which means what? Any changes made to laws which increase penalties or punishments cannot be applied from backdate. no retrospective effect. So 1 is correct, that you cannot inflict a penalty, you cannot impose a punishment or penalty which is greater than what was there at the time of commitment or commission of the crime. So 1 is correct. Second one. Now, we all know that Article 20 no ex post facto law is only limited to criminal cases, not civil cases or tax laws. However, this might make you feel that statement 2 is correct, because retrospective application of civil laws is allowed, tax laws is allowed. But if the retrospective effect results in enhancing penalties, that is not possible. So second statement is actually wrong, because you can allow the application of laws from a previous date, but it should not result in increasing any punishment or enhancing the penalties. That is the criteria. So 2 is wrong, 1 is right. A1 only is the right answer for this question. That brings us to an end of our discussion for today. Let's meet tomorrow. Till then, that is all for me for this video. Jai Hind.